Thank you all for joining us today for our webinar on visa to green card options. My name is Dustin Saldarriaga, and I am a senior associate with Scott Legal PC here in New York City. Ian Scott, the founder of our firm, may be joining us a bit later. He had something come up, so I will be filling in for him momentarily. So let's today during this presentation, basically, as the title suggests, we're going to be talking about at a relatively high level view considerations if you're looking at moving from a visa, meaning a non-immigrant visa, a temporary visa, to a green card or permanent resident status. I say a high level view. We're not going to go into too much depth on any of these options. If you are interested in learning about any of these in more detail, I would recommend that you visit our YouTube channel. We do have longer webinars on each of these options. And of course, those webinars are completely free. So do check those out. Each of those is going to be about 30 minutes to an hour long on each of the options we'll be talking about today. So there's a great amount of information there. Before we get started, a few housekeeping items. If you do have questions, feel free to send them in through either the question and answer function on Zoom or the chat function on Zoom. I will be monitoring those. I do plan to get to all of the questions before the end of the presentation. Also, at the end of this presentation, we will be reaching out to you by email with a link where you can sign up for future webinars. We do these webinars on, again, a variety of topics, family-based immigration, employment-based immigration, the full spectrum of U.S. immigration. So we do hope to see you on future webinars. We try to do at least one or two a week typically. Just one second. I want to make sure. Perfect. So you'll be able to sign up for those at the link we'll send to you all. We'll also follow up with a link to our YouTube channel where again we have our full-length webinars recorded, as well as shorter videos, and those are also on a variety of topics. And as I noted, this webinar is being recorded, so you will also be able to find that after the presentation. And we also have an extensive blog on our website where we're proud to publish high quality information for free, again, on the full range of immigration related topics in the US. So check that out as well. If you would like to discuss the specifics of your case, we always welcome a consultation. You can visit our website and schedule a consultation by clicking a link on our site and finding a time that works for you and selecting the attorney you'd like to speak with. So it's a very straightforward process. During these webinars, we don't get into specifics of individual circumstances or cases. So that really is better fit for a consultation. So don't hesitate to reach out if that would be helpful. So with that, let's go ahead and get started. A helpful starting point when thinking about the green card or permanent resident process in the US is to understand that unlike many countries in the world, there is no point system to getting permanent resident status in the US. In other words, in some countries, you will get points for speaking the local language. You may get points based on your age, based on your degree, your work experience. The US does not have a point system. Basically, the way it works is the US has a number of categories of green cards. And if you satisfy the criteria for any one of those categories, you can apply for the green card. The broad buckets of categories are those that you see on the screen. The first very large bucket is family-based green cards. And that is where you qualify based on your family relationship. It could be your spouse, it could be a parent, a child. But that is one big bucket, is that you are applying for a green card based on a family relationship. The other very large bucket is employment-based immigration, an employment-based green card. So employment-based immigration, there are a number of preference categories. We call these preference categories. So EB1, EB2, EB3, EB4, EB5. Again, the criteria for each of those is going to be different, and we'll talk a little bit more about them during the presentation. And again, we have longer webinars on each of these on our YouTube channel. The one category we will not be talking more about is EB4, which is a religion-based green card for workers at churches, at religious organizations. We will not be talking about that more. But the other categories we will. So those are the two large buckets. If you are in the US on a non-immigrant visa, again, the topic of today's presentation is for those who are on a visa. So when I say on a visa in the US, I mean a non-immigrant visa, a temporary visa. That could be a student visa, an F1, could be an employment-based visa, temporary visa, an H1B, for example, a TN, an E2, which we handle very often. But a non-immigrant or temporary visa is distinct. It's very different from a green card. So how do you move from that temporary visa to a green card? And these are the two main ways that people do that. So let's talk a little bit more about these two buckets. Family-based green cards. One of the first things to consider if you are trying to qualify for a green card based on your family relationship, the first question is going to be, what is your relationship to that person? Because if you are applying based on an immediate relative, so what that means is a US citizen spouse, an unmarried child who is under 21 who's a US citizen, or a I'm sorry, if the child is under 21 and has a US citizen parent, then the parent can sponsor the child. Or if the child is a US citizen and the child is 21 or over, then the child can sponsor their parent for a green card. So in each of those three scenarios, that is considered an immediate relative petition. Now, those petitions where there is an immediate relative, they basically get a very streamlined and faster process. So, and the reason for that is that green cards are always available for that category. So for US citizens sponsoring their spouse, there is always going to be a green card available for that spouse. For a US citizen child who's 21 or over sponsoring their parent, there's always going to be a green card for that category. And for a parent who is a US citizen who's sponsoring their child who is under 21, there will always be a green card available to them. That makes a huge difference, as we'll see in a moment. We'll take a look at the visa bulletin, and the visa bulletin talks about how long the wait is if you are not in an immediate relative category. So let's look at that now, actually. So if you are not in an immediate relative category, then you fall into a preference category. If you're at your computer right now, I would recommend that you Google Visa Bulletin, US Visa Bulletin, and the most recent one that was published, these are published monthly. So the most recent one is currently November of 2024. They've published the one for this coming month. And what you'll see if you scroll down is you will see that there are several tables. The first table is for family-sponsored preference categories. And again, these are for those who are not immediate relatives. Okay, so you'll see if you're looking at the table, the categories are F1, F2A, F2B, F3, and F4. So F1 is unmarried sons and daughters of US citizens. So these are adults. Okay, these are those who are 21 or over. So again, an immediate relative would be someone under 21. But if you're 21 or older and your parent is a US citizen, you can be sponsored. You're just not an immediate relative. You're an F1. So as we see, if you're looking at this on your computer right now, you'll see if you fall into that category, so the unmarried son or daughter of a US citizen, 21 years old or older, then if you are from China, born in China, right now, they are considering applications that were filed in 2015. So there is a 9-year delay on the green card being available. If you fall into category F3, which is married sons and daughters of US citizens, again, 21 years old or older, Then if you were born in let's say Mexico, there are currently visas available for those who applied in 2000. Okay, so a 24-year delay. That's why being in the immediate relative category is a huge benefit to many people because, again, green cards are always available. Why is there such a long delay on, say, category F3 or F1? The reason is the way that green cards work in the US is that the US Congress basically decided they passed a law to say a certain number of green cards will be available to this category of people. A certain number of green cards will be available to this category of people. And so they literally established how many green cards would be available in each category. And if more people apply for the green card in a given category, then that year they won't be issuing enough, and the line continues to grow and grow and grow from year to year. So that is why you'll see in category F3, they're looking at people who applied in the year 2000 because the line is so long for that category. And unfortunately, when we talk about immigration reform, this is oftentimes one area that is looked at for reform is how to change the system, make it more efficient, maybe grant more green cards in certain categories. But unfortunately, that reform has not happened. We're not sure if or when it will happen, but we can stay optimistic. So anyway, that is a broad overview of bullet one on your screen, the immediate versus preference categories under family-based green cards. Now, looking at the second big bucket, employment-based green cards, this is slightly different. So whether you fall in EB1, EB2, EB3, EB4, or EB5 really depends on the type of green card you're applying for. And we'll talk about these in more detail. EB1 is for those who are really the leaders in their profession, in the world, leaders in the world in their profession. So these are people who have won national or international prizes in their field. They have been published. They are seen as thought leaders and industry leaders. The EB1 is truly for those who are very accomplished in their field. The EB2 is for those who are accomplished but less accomplished. And again, we'll talk more about EB2. EB3 is even a step down. It's a little less demanding than the EB2 even, and can include unskilled workers. EB4 for religious workers. EB5 is for those who are applying based on investment. So when you hear about the golden visa or the millionaire's green card, the EB5 is typically what's meant by that. And that is for those who invest at least $800,000 into a business that then creates 10 jobs from that investment. So you see how you need to decide which of these categories you qualify for, and you will apply for that specific category. Again, based on your qualification. Now, the delays do apply to these employment-based preference categories as well. So again, if you're at your computer, continue scrolling down the visa bulletin, and you'll see a couple tables that apply to employment-based preference categories. And you'll see there are categories that say first, second, third, fourth, and fifth. And you'll see some of these have subcategories. So for example, the EB5, which I said was the millionaire's visa, the golden visa, has several subcategories. So there is fifth set aside for rural. So that means if you are investing in a business that's in a rural area, they actually set aside 20% of the EB5 visas for that. There's also a set aside for high unemployment areas, programs, projects that are focused on infrastructure. So you really, that's the relevance there. But let's take an example similar to what we discussed before for family-based preference. If you are in the second category, so that would be EB2, and you were born in India. Right now, green cards are available for those who applied in July of 2012. So a 12-year delay for the EB2 category for those born in India. And it really is, if you have it on your screen, in many ways, it's intuitive how to read the tables, but you're going to find the country where you were born, not the country where you have a passport from necessarily. They may be the same country, but if they're different countries, let's say you were born in India and you have a passport from Canada, you've received Canadian citizenship. Unfortunately, you would be in the India category. There's an exception if your spouse has different nationality, but we're not going to get into that in this presentation. Reach out to us if that's relevant to you. But by and large, you're looking at the country you were born in, and then you're looking at the category you're applying in to figure out when a green card is likely to be available. Now, one quick note, again, we're not going to get into too much depth on this, but these visa bulletins are published monthly. And so as the federal government's fiscal year starts in October, ends in September. So you do see some progress on these dates over the course of the year. And sometimes there are retrogressions. Oftentimes there are retrogressions where they'll actually move backwards. You'll lose a year or 2 years, sometimes more. That can be very frustrating. But anyway, the visa bulletin really is the guiding document to figure out how long the line is to get a green card in a certain area. With that, let's go ahead and move on. I already actually touched on a good amount of the good number of the bullets on this screen. We talked about what immediate relatives are and how if you're not an immediate relative, you are in a preference-based category. We talked about the backlogs, which again are shown on the visa bulletin. Let's talk a little about the process. So there are two main ways to get a green card, and colloquially, the word green card is used a little bit loosely because it is in general an immigrant visa. There are kind of several things at play here. One is let's just talk about what a green card is. So a green card is basically what you get. It is a physical card that says you are a permanent resident of the United States. There are a couple main ways to get a green card. One is to apply at a consulate. If you do that, you are going to file in general, a DS-260 at the consulate. This is once you've been approved. And then you'll go to the consulate, you'll have your interview, and you will get an immigrant visa in your passport. Typically, you have 6 months to enter the US after you get that immigrant visa. Immigrant visa, in contrast to a non-immigrant visa. An immigrant visa means you intend to stay in the US once you get there. A non-immigrant visa, again, is a visa where you don't intend to stay there, a student visa, an H-1B, something like that. So you'll get an immigrant visa in your passport. The moment you enter the US, basically the government is going to begin processing your green card, meaning printing it, actually making the physical card, and we'll mail it to you. So within a few weeks or a couple months of you entering the US on your immigrant visa, you will actually get your physical green card in the mail. That is one way to get your green card, and that's called consular processing because you're applying at the consulate. If you're in the US, let's say you're in the US in H-1B status, you can apply for your green card from within the US, and that is called adjustment of status. Different from consular processing because you never need to actually go to the consulate. You can do all this from within the US if you're already here. You would file, and that's what you're seeing on your screen. There are two main steps. You would file, first of all, the petition to basically apply to the government and show them objectively that you qualify for the green card. So that is going to be for a family-based petition, what's called an I-130. That would be filed with USCIS. And once USCIS reviews the I-130, and what they're looking for there is if it's a family-based application, they're just looking for proof of the relationship. Could be a birth certificate, could be a marriage certificate. You're basically showing the government, I qualify for this category. So that would be the I-130. If it's employment-based, it's usually going to be an I-140 form. If it's an EB-5, it'll be an I-526 form, but you're going to file that stage 1 petition with USCIS. If that is approved, then you can file the I-485. You see that on your screen. The I-485 is basically the application for the green card. So I-130 is basically asking the government to confirm that you qualify for the green card. Once that's approved, you actually apply for the green card, and that's the I-45. The I-45 is also a big deal because when you file the I-45, you can at the same time apply for work authorization and travel authorization. So before you have those two approvals, work and travel authorization, if you're going to work, you need underlying status. So you need H-1B status, you need TN status, and you're basically working on that status. If you don't have underlying status to work, then you do need to wait for the work authorization before you start working. Similar with travel authorization, typically, once you file the I-45, if you leave the US before you get your travel authorization, you abandon the I-45. So it's very important to wait for travel authorization after you file the I-45. And usually the way it works is that when you file the I-485, you'll file both the application for work authorization and the application for travel authorization. And those typically do take a few months. I think right now they're taking between probably 3 and 9 months. I haven't checked recently, but between 3 and 9 months for work and travel authorization. So there may be a period there where you cannot travel and cannot work. If you do travel, you're abandoning the application. There are a few more stages in the process but what I just shared with you are the broad strokes of an adjustment of status application. Again, you're within the US in one status or another, and you are applying for the green card within the US without going to a consulate. That's called adjustment of status. That's what I just described. And we'll talk about a few more details a bit later in the presentation. So let's talk a bit more about the employment-based categories. So EB1A, as I mentioned before, is the first preference category in the employment-based bucket of green cards. This green card really is, again, for those who are leaders in their field, and you need to meet at least 3 of the 8. I think there may be there you'll see a 9th on your screen, but that is really because there is a subcategory for the arts and the performing arts. But take a look at these 8 criteria. You need to meet at least 3 of these. So you see that these are quite high level achievements. So some common ones: evidence that you've been asked to judge the work of others, for example, on a panel or individually. Evidence of your original scientific or scholarly contributions to the field. Evidence of your performance in a leading or critical role in a distinguished organization. Evidence that you command a high salary relative to others in the field. So you do need to show at least 3 of these 8. Now, unfortunately, even after you meet 3 of these 8, there is an additional layer of discretion that the government has. So basically, USCIS is going to look at your whole application, even after you've satisfied these 3 criteria at least, and decide as a whole, do you appear to be someone who satisfies the EB1A? And that is sometimes challenged in court, but it is a very frustrating part of the process where USCIS, this is not entirely an objective process. USCIS does exercise discretion here. Now, fortunately, the EB1A does allow self-petitioning, meaning you do not need an external employer. You can be an entrepreneur and apply for the EB1A. As I described before, there is a 2-step process. You would first file the I-140, and then once the I-140 is filed, you would file the I-485 with work and travel, the application for work and travel. And we will talk a little bit more about the perm process, but one of the great things, especially actually on the next screen, let's talk about this a bit more, is when you apply as an entrepreneur, you get to, for a national interest waiver, you get to bypass the perm process. So let's talk about what that means. So EB2 is for those who are not necessarily at the level of an EB1A applicant, who's not so you're not necessarily a leader in the field, but you still do qualify as a quite exceptional candidate. So EB2 has two subparts. You're either applying for the national interest waiver, which is what we'll talk about on this screen, or you are applying based on PERM. So PERM is when there is an employer who's going to employ you and they need to go through additional steps to employ you in the EB2 category. EB2 is basically when you own your own business, you're an entrepreneur, and that business or your work, this could also be for where there's a US employer, but oftentimes it is for entrepreneurs whose endeavor is in the national interest. So you are accomplishing something or aiming to accomplish something that really does benefit the United States in some way. So the EB2 national interest waiver, I should also say, is also a very common choice for those who are on E2 visas. So they've started a business, that business is in the national interest in some way. The EB2 can be a wonderful option to pursue if you qualify. So let's talk about how you qualify. So there was a case, I believe it was issued in 2017 called Danisar. You see that case on your screen. If you're interested, it's a wonderful case to read because basically what it did was it made very clear that entrepreneurs qualify for the national interest waiver, and it looked at how you can qualify as an entrepreneur for the national interest waiver, EB2 national interest waiver. So the endeavor needs to be of national importance. Don't be afraid of that term because national importance does not mean that every single state in the union is benefited by your endeavor. That's not what it means. National importance is really more looking at something that is beneficial to the country in general. So it could be creating jobs for a socioeconomically distressed area, that you're either in a rural area or an area of high unemployment and you're creating jobs for that area, a significant number of jobs. That could be arguably sufficient for the national interest waiver. And actually, Danisar is explicit about saying that could qualify. Your endeavor could also be focused on a certain topic that's in the national interest. So oftentimes this could be like defense work, or it could be research. Say research on a laser technology or artificial intelligence, if you can make the argument that it benefits the United States in some way. So how do you convince the government that your endeavor is actually in the national interest? Typically, it's through expert letters. So you would think very creatively, and we do assist our clients with this, about what politicians, what business leaders, what other kind of leaders in the field are willing and able to write letters about you and about your endeavor, talking about the importance for the United States. And that those expert letters really are key in the NIW national interest waiver application process. So you do need to show, part one, that the endeavor is or will be of national importance. The second requirement for an NIW, national interest waiver, is that you, the applicant, need to be well positioned to advance that proposed endeavor. So the first requirement is looking at the endeavor itself. Is it in the national interest? The second requirement is looking at you as an applicant. Are you qualified to or well positioned to advance that endeavor? And it's looking at your work history in the past. It's looking at your education, and just confirming that you are qualified to push forward that endeavor. And the third part of the national interest waiver is that the government should waive the labor certification process. So this is what I was talking about before, where in general, for EB2 or for EB3, we'll talk about this on the next slide, there needs to be an employer that advertises the job, that sees if there's a qualified US worker. It is a very long process. because the national interest waiver doesn't make you do that, so it's a huge benefit, you need to argue in your application why you shouldn't have to go through that process. For entrepreneurs, this is usually very straightforward. Just by virtue of being an entrepreneur, you are a job creator rather than competing for a job. And that is a very strong argument that the government has accepted. But if you're not an entrepreneur, then you do need to think about, or your employer does need to think about the arguments as to why the labor certification process should be waived. Maybe there's a benefit to making the process significantly faster, and you want to get your skill set and the endeavor started sooner rather than later, for example. Now, one thing that's oftentimes overlooked for the NIW is that there are still threshold requirements. So just because you have an endeavor in the national importance and you're well positioned to advance it does not alone qualify you. You do need to have either an advanced degree, meaning a master's or higher, or a bachelor's degree plus 5 years of progressive experience in your field, or you need to show that you have exceptional ability. So exceptional ability is going to be similar to, though not as strict as what we saw on this screen. So the requirements are different. But just to give you an idea, it is similar where you're looking at a number of criteria and you're checking, okay, I have that one and that one and that one. So you do need to satisfy that threshold requirement, advanced degree or bachelor's plus 5 or exceptional ability. Now, I've mentioned perm a couple times. So perm is, again, a subcategory of the EB2. If you're not doing a national interest waiver, you need to do perm. Or if you're in the EB3 category, you must do perm. The EB3 category does not have something equivalent to a national interest waiver where you can self-petition. So perm is when an employer in the US is basically sponsoring you as the worker. So it's a three-step process. Perm being the first, filing the I-140 being the second part, and filing the I-485 being the third part. I already talked about the I-140 and the I-485, so let's talk about perm. Perm is basically the process when the U.S. employer is, first of all, applying to the U.S. Department of Labor to confirm what the required wage rate for the worker is, and that's called the prevailing wage. It is always going to be higher than the minimum wage. So basically, the employer would apply to the Department of Labor, would say, we want to employ a foreign national in this job. What is the prevailing wage we need to pay? And the Department of Labor is going to take months and get back to the employer and say, here is the wage you need to pay. Again, that process does take months, could be 9 months, could be a year. Once that prevailing wage is received, then the employer will advertise the job and will draft a job description that really shows the minimum requirements. You cannot, as the employer, you cannot kind of tailor the job description so that you're only making the applicant eligible. Let's say they're fluent in Mongolian and you decide, well, I can eliminate a bunch of US workers by requiring Mongolian. You can't do that. So you really do need to only express the minimum requirements for the job, meaning you would accept someone with those requirements. They're the minimal requirements you need to accept someone for the job. You'd advertise the job. If there is a qualified and available US worker for the job, you need to stop the process, unfortunately. So you can't take the foreign national if there's a qualified US worker. But if there is not a qualified US worker, then basically you would complete the perm process, gather all that documentation showing you advertised the job, etc. There was no qualified US worker. And then you would move on to the I-140 phase. So you can see how this perm process is a quite demanding, quite time-consuming process. So if you're able to do something like the national interest waiver and bypass this process, it can be a huge advantage. Again, the EB1 does allow self-petitioning as well, so could be a huge advantage to avoiding the perm process. Um, and as I mentioned before, after the I-140 is approved, you can file the I-485. So let's move on to the EB-5. The EB-5 again is oftentimes called the golden visa, the millionaire's visa, because it is based on investment, but not just investment. That investment needs to create at least 10 jobs for US workers. So the EB-5 technically is called a job creation green card. And proving that your investment has created those 10 jobs or will create those 10 jobs really is at the heart of the EB-5. So that's important. You see on your screen that you need to invest either $800,000 or $1,050,000 into the business. The reason there are two different values is because the government does give some preference to those who are starting businesses in rural areas or areas of high unemployment. So these are called TEAs, targeted employment areas. If the EB-5 business is in a targeted employment area, which again is a rural area or an area of high unemployment, you can qualify with the lower investment amount of $800,000. If you are not starting a business in a targeted employment area, you need to invest that $1,050,000. And that amount as well, keep in mind, is the amount that actually needs to be put into the business and made available for job creation. So actually growing the business. That does not include administrative fees. So let's say you're applying through through a regional center, for example, and there is a $50,000 administrative fee. That $50,000 administrative fee is on top of the $800,000 or the $1,050,000. So be very careful of that. Most regional centers are going to know that, but just be aware that you do need to have more funds available in general than just 800,000 or 1,050,000. You need to include those administrative fees as well. I mentioned regional center, and I'll just quickly say that within the EB-5, there are really two main ways to apply for the EB-5. One is a regional center, and the other is direct investment. I'll start with regional center because the vast majority of EB-5 applicants go through regional centers. Regional centers are very large projects, usually building a shopping mall or building a subway station, some large project requiring tens of millions, if not hundreds of millions of dollars, could be a resort, for example. And the regional center will draw dozens of EB-5 applicants and will collect all that money to go toward the resort or the shopping mall, for example. So a regional center, again, can support more than one EB-5 investor. And usually the regional center is going to handle a lot of the administrative work. And that's why there is usually an administrative fee there. Regional centers are also almost always going to be in targeted employment areas. So they're going to have that lower $800,000 investment amount. They're also relatively passive opportunities for the EB-5 investor. So if you're looking at an EB-5, you don't want to actively run your own business. You just want to invest money and and wait for the green card, then the regional center is going to probably be the best option. But if you have a business and your business is doing well and you actually want to actively run your business, then the direct investment option could be a good one. We do handle both of these applications, both types, regional center and direct investment. Just to give an example, one of our direct investment clients runs a restaurant, and it's a very successful restaurant. So that is a good example of what would make a good direct investment project. You invest $800,000 into your restaurant, assuming it's in a TEA. That $800,000 leads to the creation of 10 jobs for waiters, waitresses, bartenders, etc. That could be a great EB-5 investment. So the new commercial enterprise, I'm going to go through the bullets on your screen. That is the name of an EB-5 business. So legally, it's called a new commercial enterprise. Investment that can be included, it's fairly broad. However, you need to closely document where you got the money from. So that is going to be the biggest hurdle to an EB5 is having all the documents to show exactly where you got that $800,000 or the $1,050,000. And those funds do need to be the applicant's personal funds. So if the funds are from a loan, the loan needs to go to the applicant before they go to the EB5 business. If they're a gift from a parent, they need to go to the applicant's personal account before they go to the business. You cannot use retained earnings in the business because those are not your personal funds. Those are the business's funds. So those retained earnings need to be distributed to the applicant, taxes paid on them, and then invested back into the business before they can count as investment for EB5 purposes. There's a bullet here on differences between E2 and EB5. There are many differences, so I'm not going to talk about many of them. We do have other webinars on both the E2 and EB5. Check those out if you're interested. Schedule a consultation because the EB5, if you're considering it, is very complex and is very heavy when it comes to regulations. I mentioned the source of funds, very complex. Consider it like a financial audit that you're just going to have to track every single dollar that went into the EB5 business from its source. Job creation. Your investment does need to lead to 10 full-time jobs. So the timing is very important. You need to make your investment before those jobs are created. So let's say you have an E2 business. It's done very well and you invested $100,000 5 years ago and you have 10 employees, and you say, great, I want to apply for an EB5, so I'll just put $800,000 into the business and apply. Not exactly going to work that way. So even the 10 jobs you had before your investment are not necessarily going to count. You need to make sure those jobs grow from the investment. A detailed business plan is typically a very good idea for an EB5. And the EB5 filing, again, this is going to map onto what I said before regarding there being kind of two phases. Phase one is going to be the I-526. Phase two is going to be the I-485. One of the nice things about EB5 right now is if you are current, again, you look at the visa bulletin, look at the EB5 category, fifth preference. If it says C there, C means that green cards are currently available. Then if you're in the US, you can file the I-526 and I-485 at the same time, and that can be a huge benefit because that means, again, you can apply for work authorization and travel authorization when you file the I-45. And that actually is new after the recent law that was passed in 2022 or 2023. So a huge benefit if you're in the US and the green card's current. Now, EB5 does have one third step of the process because when you file the I-45, excuse me, when you file the I-45 for an EB5, you don't get a green card that is without conditions. You get a conditional green card. And the government requires that 2 years after you receive your conditional green card, you apply to remove those conditions. So basically what they're looking at that final phase, which is called the removal of conditions, you apply to remove your conditions by filing a form I-829 with USCIS. You are showing the government you've sustained your investment and created the 10 jobs. So there is a time frame you have on creating those 10 jobs, but by the time you apply to remove your conditions, you really do need to show investments made, jobs are created, you're ready to remove the conditions for your green card. So that is one third step in the EB5. We're not going to spend too much time on these, but there are some other green card options. There's a diversity lottery, which really is a lottery. You file an application and hope you win. Keep your fingers crossed, and you may be chosen for a green card. Every year we have at least one client who's chosen for this, so it doesn't hurt to file a diversity lottery application if you're interested. There are also humanitarian-based green cards. So if you have excuse me. If you have asylum special immigrant juvenile status, you may qualify for a humanitarian-based green card. Similarly, there are green cards for those who have special circumstances. So, for example, the U visa or the T visa, which are for victims of crimes or victims of trafficking, or for those who have information on those crimes. Those visas, the T and the U, could not automatically, but with some additional steps, lead to a green card. And finally, as I mentioned before, there's always the hope that the US government will clean up its act when it comes to US immigration, reform the system, make it more efficient and fair, frankly. But no end in sight to the current system, unfortunately. And some final considerations before we turn to the questions. I know a few questions have come in. And if you do have questions, go ahead and send those in. Timing is really key. For example, the EB-5, the millionaire's green card I was talking about, that process from the I-526 to the I-829 can oftentimes take 7 years. So you see why filing the I-485 and the travel and work applications is significant, because if the process is going to take 7 years start to finish, it makes a very big deal, a very big difference to be able to apply for work and travel permission relatively early in the process. Again, we've talked about the visa bulletin quite a bit, but you always do want to follow that visa bulletin based on your country of birth and your preference category to get a sense of whether your place in line is moving forward, moving back, and gives you a sense of how long you might be waiting. Travel considerations and visa expiration dates. I've mentioned travel considerations. Again, once you file the I-485, you don't want to leave or else you abandon it. But the other travel consideration is if you're in the US on a non-immigrant visa. Let's say you're in the US on a TN visa, non-immigrant visa that allows you to work in the US if you're a national of Canada or Mexico. You need to be very careful once you file a green card application. The government is going to be aware of that. And if you're leaving and coming back in on a TN, or if your TN is about to expire and you need to renew your TN, then you will very likely get questions about your intention to leave at the end of your TN visa. Excuse me. Because again, the TN visa is a non-immigrant visa. So what the government is always going to be looking for is that you, in fact, intend to leave at the end of your stay in TN status. And I'm using TN as an example. This would be the same for a number of other visas, with a couple exceptions that I'll mention. But point being, applying for a green card does serve as a kind of flag to the government, where they may ask you additional questions about your intention to leave the US. There are some ways to protect against this. One is to do consular processing so that you actually can tell the border official you must leave the US before you get your green card. You actually are not planning to adjust status in the US, which can be an effective explanation. The other is to change to a dual intent visa. So the H-1B, for example, does allow you to apply for a green card while you're in H-1B status. So some people on a TN may want to change to H-1B before applying for a green card, just to reduce the likelihood of facing issues when they renew the TN, or renew their visa or travel. Um, uh, and and that is related to dual intent considerations, this next bullet that you see. So dual intent is basically a visa option that does, even though it is a non-immigrant visa, it does allow you to apply for a green card. The fourth bullet you see is parallel green card strategies. There is no prohibition on applying for more than one green card preference category. So let's say you come to the US, you have an employer who wants to sponsor you. It's an EB3, so you're looking at 7 or more years in line for that. but you fall in love with a US citizen, you can certainly file that green card application for the US citizen, sponsored by the US citizen spouse, while the employment-based category is moving. Or if you file the EB3 and let's say get another job opportunity, there may be a way to change the preference from EB3 to EB2, for example. So no prohibition on filing more than one green card, and there may be strategies to do that. And underlying all of this is the importance of planning. So talking with an immigration lawyer early in the process can really help save you time and stress throughout the process and pick the right pathway for you given your qualifications and circumstances. So with that, we'll go ahead and turn to questions. I know a number of questions have come in, and feel free to send those in. We have 8 minutes, so happy to turn to those. And I believe, Ian, have you joined the call?
Yes, I have. Yes,
Perfect.
Dustin.
So we have Ian here.
Excellent. Yes,
Great.
yes, yes.
So first question, does an approved I-140 of an E2 dependent for immigration intent prevent E2 renewal and employment authorization of the E2 dependent? So this is a great question. And of course, Ian, feel free to jump in. I'm happy
Sure.
to begin answering, but please feel free to let me know if you'd like to. So this is related to what we were talking about at the end here about dual intent. So the E2 is a non-immigrant visa. You need to convince the government you don't plan to pursue adjustment of status inside the US. So the answer is that yes, an approved I-140, you should assume that the consulate and the border officials are going to be aware of an approved I-140 if you or the spouse is going to try to renew the E2. Now, that does not mean that you can't or the spouse cannot renew the E2. You can, you just need to be strategic and obviously honest about how you do that. So selecting consular processing is one thing you can do rather than planning to pursue adjustment of status. So consular processing can help, checking that box at the start, being prepared to talk with the border official about that and explain that you do not plan to adjust status in the US. Ian, did you have anything you would recommend
Yeah,
on
no, I
that?
think I think that's right. I mean, I think that the big issue is that, and I think it goes back to one other thing you said, Dustin, in the last slide, is the timing is everything, because you don't really want to be in a position where you have to do the renewal of a non-immigrant visa when you have a green card petition pending, because things could come up during that. And as Justin said, you do have to kind of prove that you don't plan on adjusting status. And if you go to a consular interview and they see the I-140, and as Justin said, they will see it, because I think there's a question about it on the DS-160 that asks about whether or not you have an immigrant petition pending. So it's just something that requires a lot more explanation. So timing, like, a lot of the time, if you're deciding to do an I-140 under, let's say, an EB1 or a national interest waiver category where you have some flexibility, it may be better to try and renew your E2 or non-immigrant visa before you actually do that, right? Because if you know that you have several years, if you renew your E2 visa and you have 5 years before you have to go to renew it again, then it's likely in that period of time you'll be able to actually get the green card. So yeah.
Perfect. Second question, for an individual, Indian-born individual, the gap in dates between an approved I-140 and priority date to become current is in years. Yes. Is there a provision that the individual can stay and work in the US? So this is going to, excuse me, this is going to come down to really your underlying status. And this is not uncommon, especially for those born in India, where you are looking at 5, 10, 15 years before the green card will be available. You do need to apply for a visa that you qualify for. It may be an H-1B. Even if you're born in India, if you have citizenship in Canada, for example, you could apply for a TN. And if you do face pushback, again, as Ian was saying, it is a valid point to make that your green card's not going to be current for years. So, again, there are people in that scenario, but you need to maintain your underlying non-immigrant visa status, and that is easier said than done. But I do think a qualified immigration lawyer can help with that, and it's going to come down to what the opportunity is in the U.S., who the employer is, which visa you qualify for, and just keeping that valid. Um, so, what about healthcare workers on a TN visa born in Canada applying for an EB3? What would be reasons for approval or denial? It's really coming down to what we discussed before. So, EB3 has multiple stages. It does have the perm process. So, possible reasons for denial start with that part of the process. Is there a qualified US worker? Are you qualified for the EB3? But the government's really going to go through the every step of the process to make sure you're qualified. But that is probably, do check the visa bulletin, because you are probably looking at a quite extensive process. But again, not to repeat repeat ourselves, but that is an area where if the green card is denied, you're going to want to tread carefully with the TN and renewing the TN, because the government does tend to be sensitive about renewing TNs when there's a pending application. Um, how do I consider the risk for an entrepreneur being currently on E2 to be denied an E2 renewal if we tried to file for EB2 or through family sponsorship? Um, it is important to be aware of the risk, meaning if you file a green card application, whether through EB2 NIW or family sponsorship, it does indicate to the government some intent to stay in the US. But that being said, there is no prohibition on filing those applications. So filing an NIW or family sponsorship, and again, you want to be careful about how you do it. The timing of it, perhaps renew your E2 before you file the green card application, consular process the green card application. Be ready to have that discussion with either the border officials or the consular officer. Those are all important things to do. Um, what happens if you're on a work visa, say an H2A, and have currently filed your I-140, but your priority date is still a year and a half out, and your work visa will expire before? Can you stay in the US while waiting? So you need to have an underlying status. So I'm assuming here that you have not filed the I-485 and have not, because once you file the I-485, you can stay in the US once the I-485 is filed. But this question is the I-485 would not have been filed as I'm reading it. So in that case, you need an underlying status. So if your H2A status is expiring, you need to make sure to either extend your status, change your status, or leave before your I-94 expires. And that's very important.
Yeah, and the one
Um,
and one just one addition as well is that there is one kind of, I don't want to say exception because it's still the same thing that Dustin said, but where if you are on an H-1B and you have an approved I-140 and you, let's say, for example, that your priority date is quite delayed, like delayed for 10 years or 12 years or even 15 years. If you have an H-1B, there is a kind of exception that allows you to continue to renew the H-1B, even though normally H-1Bs someone can only have an H-1B for 6 years. But if you do have an H-1B and you have a pending, you have an I-140 that's been approved, you can continue to, and then you have your priority isn't current, you can continue to renew the H-1B indefinitely until the case has been resolved. So it's not that the filing, the filing of an I-140, an I-526, or an I-130, whatever that first step of the green card process, that never gives you any underlying status, right? Never, ever. But in this case with the H-1B, one way to kind of maintain your underlying status in a situation where otherwise it would just run out is with the H-1B. So.
Perfect. And that's a nice segue to the last question. Currently, I have a TN visa. I might need to travel in the future due to my job. I might be able to switch to an H-1B. Can I apply for an H-1B if I'm in the US? You can. You would file a change of status application. Now, the important thing to know about the H-1B, and this person has asked about the timing, is that the H-1B does work on a very strict time frame that's aligned with the US government's fiscal year. So you would need to wait to start work, assuming you are selected in the H-1B lottery. You would not be able to start work before, I believe, October of
Mm.
2025. So you're looking at a significant delay there. But good question for a consultation if you do want to follow up on that. This video is being made available on YouTube, should be available within a couple days to respond to that last question. Um, and I want to thank you all for the great questions. We are at 11:02, a couple minutes after. Ian, thank you
Thank
for
you.
sharing your expertise. Do keep an eye out for the email we'll follow up with a link to the video and a link where you can sign up for future webinars. We really do sincerely hope to see you participating on those as well. So have a great day. Stay well
Great.
in the
Thank you very
meantime.
much, Dustin. Okay, thank you. Take care. Bye.
Bye bye.